Judge Chesney, I'm so glad you're here, and we want to thank you for joining us. We're at the Hyatt Regency Conference Center for the July 2014 beginning of the 9th Judicial Circuit annual meeting, and we're here for the Oral History Project with the 9th Judicial Circuit Historical Society. My name's Leah McGarrigle, and again we want to thank you for working with us. And we have about a half an hour. We'd just like to touch on some topics about your career in the law.
Well, thank you for having me.
Starting with your decision to become a lawyer, and if you could tell us how that came to be.
Well, I kind of fell into it. I had planned to take a degree in psychology, to go on in that department, and somewhere along the way I just got the idea that maybe I didn't want to do that. So I thought about other things I could do, and the one career that didn't really require any prerequisites was the law. So I didn't really have a calling. I just thought I'd give it a try, and it turned out very well.
And we're talking about 1960s,
Yes,
and about 5% of the law school class was women.
Yes, 5%. We had 15 women out of approximately 300, a little less than 300 in our class originally. And that was the biggest class that Bolt Hall, now Berkeley Law, but I'll probably never call it Berkeley Law, but Bolt Hall had ever seen. The previous class, I think, had 7 women. And so when we arrived, people looked at us as if we were now overrunning the school. Women were overrunning the school. One person actually said to me, "Do you know you're taking the place of a real breadwinner?" But the professors were all great, and I made many good friends at the law school, both men and women. I was very happy to have chosen that career.
It's interesting because Berkeley at that time, the beginning of the free speech movement, the anti-Vietnam War movement, so many other disability rights movement happening right in your neighborhood, and yet these attitudes about women and their place were pervasive at the same time.
Well, one of the things, and I don't think that it was across the board at the school, but certainly it was still a view held in society in general. And I think that the fact that we had 2 women in particular in our class, one who was number 1 throughout the time she was there and one who was number 3, I think served to dispel any stereotypes about how women would perform in that environment. And neither one of them was myself, by the way, but they helped to pave the way.
Did you go right from law school to the district attorney's office? I
did. I knew what I wanted to do when I got out of law school. What I wanted to do was get in the courtroom. And that just really seemed like such an exciting place to be. And I applied to a variety of offices, county counsel in Oakland, public defender in Oakland, public defender in San Francisco, district attorney, a plaintiff's personal injury firm, Melvin Belli's office, any place that I thought I could get into court fast. The public defenders did not want to take a chance on a brand new graduate and actually expose their clients to possible errors that could have very serious repercussions. But the district attorney did not have a requirement of experience. And so I got a few offers around, and I chose the district attorney's office, and I'm glad that I did. Because it was excellent experience. It was a smaller office than it is today, and I don't remember exactly how many people we had in the office, but it was a close-knit group.
What was the atmosphere like in the DA's office in San Francisco at that time?
A lot of camaraderie. There were few women There were, I think, 3 when I joined. And they were older women. And only one actually took me under her wing, and she was wonderful. But when we first got there, I didn't even have an office. What they did is they assigned new lawyers to the counter. And people just came into the counter with complaints. And the first complaint that came into me was a woman who wanted to report a murder. So I immediately took out my pen and paper, and I'm dutifully writing it down. And when we got to the victim, she produced the corpse, a dead pigeon. All right, so at that point, I started to wise up very quickly, let's put it that way. And then from there, I went to all kinds of courts that I don't even think are fully staffed anymore with lawyers. Traffic court, and then on from there to hopefully bigger and better things. I got a chance to get my feet wet with trials, and then moved ahead to felony trials.
Was the transition to being in court and practicing quite different for you than having been a law student?
Well, yes. Although I really enjoyed moot court. I think that's one of the reasons I thought I would like the courtroom, because I found that I enjoyed the experience. The challenge of having to adjust as you went along. You could not simply put everything down in advance. A little bit the uncertainty, all of that, the ability to cope with it, I liked all that. So, but yes, I had to learn a lot, and I hadn't really had that much experience out in the real world. I'd been a little sheltered, and I didn't have any stories of really making it the hard way, and so here I was, and I was dealing with the nitty-gritty of life. And I'll tell you, the state court is much different than the federal court as far as the type of crime that comes in. There isn't a lot of violent crime and street crime in the federal court. The only place it comes into play really is if there's gang-related activity, RICO prosecutions that will give them a federal hook to bring the case into federal court. But traditional robberies, assaults, violent burglaries, those kinds of crimes we don't see in federal court, but we were dealing with the real underside of humanity. And sexual crimes, sexual assault crimes, and I'm not talking about like child pornography, which we have in federal court, and it's a major problem, but these are violent sexual offenses, and I had some success in trying them at a time when people were very skeptical of this kind of accusation, if you will. Mm-hmm. There was even an instruction that was mandatory to be given in a case of forcible rape, that it's an easy charge to make and hard to disprove, and thus you should view the victim's testimony with caution. They don't give that anymore. But people were very skeptical and felt women brought this behavior on by their own provocative dress or how they acted. So in any event, I ended up heading up the first unit in, I believe, the country to specialize in the prosecution of violent sexual crimes. And we put into place all types of procedures that became a model nationally, and I feel very good about that. I think it made a difference.
How did that come about in terms of support from the administration for doing something that was that different?
Well, in great part it was their idea. Mm-hmm. They were very supportive. The district attorney was very supportive at the time, and I was coming up with various suggestions about how we could improve the way in which information about the crimes is collected and then moved from the police department to the lawyers, and trying not to lose every bit of information, well, trying not to lose any information and to keep as much as we could because we needed it. You couldn't lose it along the way in the chain of moving the case from one place to another. And so we simplified that process, which was also much better for the victims because they didn't have to keep telling their story again and again. So the collection of evidence, the retention of evidence was much more effective. But in discussing all those things and being kind of demanding of the police department, my office felt that it would be a good idea if I took another couple of lawyers, and we actually were informally referred to as the rape team, but the sexual prosecution unit, and put into practice in a wider way than just one lawyer, me. And so, yes, they were very supportive, and the police department was very supportive as well.
In terms of that program becoming a national model, did you speak about that, or did you travel to other districts?
I did, yes, I did. I went east. I wasn't on a talking head circuit, but I would be invited to places to discuss what we did, and was generally found to be a beneficial way to handle the cases. Yeah. Pretty ugly crimes. I saw a lot of ugly crimes. Tremendous number, actually.
Are there cases that stand out that you'd like to reference?
From that time, there were a lot of cases, but I think probably the one that stays with me the most was one that was dubbed the Nob Hill rapist. Nob Hill being, of course, a very fancy part of San Francisco. And there had been a series of rapes, and very violent ones in that area. And I ended up with one victim who had been assaulted. She was going into her front door, just grabbed from behind. And she fought the assailant off, and he literally went through her entire set of knives in this assault. Hopefully she was unconscious through a great deal of it. She should have been dead, but he left her for dead, and she managed to crawl, I think, semi-consciously down the hall and to a neighbor's front door. And the emergency team at San Francisco General Hospital saved her life. She had every vital organ had been perforated in some way. But what happened is she was a Japanese exchange student, very delicate. I don't know how she lived, but she did. And she eventually went back to Japan when the case had to be moved on a change of venue. And she said, I cannot come back again. So before she left, we videotaped a deposition, and it was the first time in California that a videotaped deposition of a victim had ever been used in a trial. There had been one previous case, I think it was a Hells Angel case with a murder, in which a witness had been videotaped, but this was the first time a victim had been. And I was amazed to watch how the jury reacted to that. It was like they were in their living room watching TV. They were literally glued to the television. Of course, it was a very dramatic recounting as well. But that one stays in my mind, yes.
In the time we have today, if you could tell us a little bit about how you became a state court judge, and then how you went onto the federal bench as well.
Sure. Well, this would be in the first governorship of our current governor, Jerry Brown. He was a governor at the time that I was at first appointed to the municipal court, which doesn't exist anymore. But it was the lower trial court, had about a $25,000 cap on civil cases, and misdemeanors was the highest level of crime that could be tried. He made a commitment to change the face of the bench. and to have it more reflective of the community. He said we should have women, we should have people of color, and he set out to find people who could fill the bill. And I'll tell you, at the time, there weren't a lot of women litigators. So they came to me, search committee, and then also, well, I think it was the main way that I became interested, but not really. I was only, when I was appointed, I was, what was I? Okay, I was 36 years old. And I thought, oh, I don't want to go on the bench, a bunch of old guys that I'll just be spending all my time with. But then my husband said, do you think you'd ever want to do it? I said, yes, maybe. Not really now so much, but maybe later. And he said, well, then maybe you should consider it. So I did, and I was fortunate enough to be appointed. And so I made very good friends from that time too, and gained a lot of experience in the municipal court. And then came the end of the governor's term, and he began to make, at the 11th hour literally, a number of appointments across the state, which we were referred to as the midnight appointments. I got a call while on a date, well, I should say, my husband, who had encouraged me to apply, had passed away. And so this is a number of years later, and I actually went out on a date on New Year's Eve and got the call at the restaurant from the governor, which was pretty wild.
It was cause for celebration.
Yeah. Well, that was kind of funny. But my husband, who had encouraged me, he played a very, very big role in everything I did as a lawyer and as a judge, always so supportive and understanding of how much time it took away from the home, which it does, trial work, litigation.
And did your husband have a quite different career from your career?
He was a lawyer.
Okay.
He was a lawyer. And in later years, I remarried. I remarried someone I met on the court. Oh. Yes, the court's been a very good experience for me. Opened a lot of doors. So I went to the Superior Court, and now we have a consolidated court, as you know, but not at that time. And I thought, okay, I put my name in many, many years later. About 11 and a half years later, I went to the federal bench.
What was that process like? First the decision to put your name in, and then the actual process?
Yeah, I put my name in, and the process was rather grueling. A huge number of forms you had to fill out, and then there was an initial interview. I was recommended by Senator Feinstein, and she had a whole committee process. So you started with just like one person, and went a little bigger, and then the full committee, and then your name was put in. You had to meet with the Department of Justice. The FBI screens every single aspect of your life. They called, of course, all kinds of people. They called one of my colleagues from the Superior Court and asked him if he had anything to say about me in particular, in addition to all the things they'd asked him about. And he said, oh, yes. And they said, what is that? And he said, she has very nice table manners. Then they came to my home, which is a condominium with a front desk, essentially, and security people. And they asked if I lived there, and the security guard said, I'm not at liberty to tell you. And sent them away. And I had to find out if they left a card. I said, did they happen to leave a card? I could call them back and say, yes, I really do live here. I could just see federal appointment foiled by security guard condominium. But, yeah, so, I was not considered, I think, controversial in the main, but there was one issue I expected to be questioned about by the Senate committee, which was a predominantly Republican committee at the time, and I was a Democratic appointment. On the Superior Court, I had found unconstitutional the state law that required a minor to obtain permission from either a parent or obtain a judicial court order of approval to have an abortion. And similar laws have been upheld under the United States Constitution. But the California Constitution has an express privacy provision. And I heard all kinds of testimony about these laws and a good deal of medical testimony, and I found that the law was unconstitutional under the state constitution. Ultimately, that decision was upheld by the California Supreme Court. But I expect to be asked about it at the time of my Senate committee hearing, and they didn't ask me. And I don't know why, but they didn't. I was ready to explain why it sounds like a good law if you picture your own family, but it's not every family is your family. Not every family is a good family or a supportive family. And so, and the court process is extraordinarily daunting. In fact, I heard from judges from states that had the law, and they said, oh, I felt at the beginning it would be a good law, I could counsel young women. They said, bottom line, I felt like a rubber stamp. How was I going to tell a 14-year-old who didn't want to have a baby that she had to have a baby? So, there you go.
At that point in your career, it was, you know, you had not been out of law school so many years, and you had so many big issues coming your way.
I had big issues. I had issues certainly on the federal court as well. I heard the first case in which the United States Attorney asked for the death penalty after 60 years of not having a case of that nature. And there were 3 murders, all on different days, all in cold blood. One was a federal witness. These crimes were gang-related. It was tried under the RICO statute. The defendant was only 18 at the time he committed the murders. He was only 24 at the time he was tried. He looked like a college boy. He didn't have any tattoos. He was very nice looking. We had voir dire privately with the panel to start with to see if we could, the veneer, to see if we could impanel a jury of people who were at least willing to consider voting the death penalty. And people would say, he looks so nice, I can't believe he killed anyone. I think his appearance went a long way toward the jury verdict, which was life without parole. His appearance, his young age at the time, and the fact that he'd had an absolutely horrendous childhood. He just didn't have many chances, frankly. So it was a very interesting case, a high emotion. The defense felt very responsible, of course, having this life in their hands, and very, very strong arguments and presentations all the way around, both the defense and the prosecution. And the case went on for several months. So,
I imagine in a case like that you have family members, at least on the victim side. Did you have family members in the court as well?
The families of the victims came, these victims were primarily they were primarily from broken homes. And so it wasn't as if you might have someone who had a large family support in the courtroom. But yes, the families came at the time of the sentencing presentation, because of course you have a two-stage trial. He was first convicted, then you have a penalty phase. That's when all the mitigating evidence and the aggravating evidence comes in. And there's a lot of pressure in a case like that. The jury, coming in with the verdict they did, you might think, well, were you relieved? You wouldn't have to impose the death penalty. I didn't have strong feelings about how that case should come out. Needless to say, if I had had to impose the death penalty, it would have been, taken a very serious toll. It can't help, but you do that, I think, But and I had one other case involving the death penalty, and that was a case in which someone had been convicted in state court a number of years earlier. He'd been in prison for, oh my goodness, probably 16 years by the time the death penalty was about to be imposed. And his lawyers came in with a request for a temporary restraining order on the following theory, which was novel to say the least. He had been denied clemency. He had filed a clemency petition, and the material he put in his petition was material that he had been led to believe by the governor's office would be the type of information the governor was interested in. And in fact, the governor was not interested in that information. So of course the argument from the state attorney general was that you don't have a right to clemency. You can't have violated any constitutional right. But it seemed to me there was an issue there. And so I heard them all out. In the meantime, the lawyers for the defendant are going on, and I started pointing to the clock. I said, gentlemen, the clock is ticking. And so just 6 hours before he was going to be executed, I granted the TRO. He had already had his last meal. He had already been moved to a suicide watch cell. And then that decision was upheld by the Ninth Circuit, who did feel there was a serious question that was raised. He ultimately made his pitch, so to speak, filed a new petition with the incoming governor, which is what I think his whole hope was, that he would have new ears and eyes to review his petition. It again was turned down, and he ultimately was executed. He had a lot of support from the community in support of clemency. There was a real question about his role in the crimes, but he had originally been led to believe nobody wanted to hear that. They just wanted to hear how he had conducted himself in prison. So the second time around, he put in the other evidence, but it didn't help him. He was still executed.
These are really interesting stories, Judge, and we don't hear a lot about criminal cases like this.
No, well, we get, of course, everything in federal court. I've had 8 million, I've had 8-figure patent cases. In the same light, I've heard cases involving whether the pit bull neutering law should be enforced, whether Happy Meals violate some form of business practice, whether mergers of hospitals are anti-competitive. and whether I should hold up a merger in that respect, which I did not do, and Summit Hospital goes on to this day because I did not enjoy that merger. Many types of cases, obviously. 2 rookie cops who killed an undercover police officer who they thought was robbing and about to kill a citizen. So civil suits of every kind you could imagine. And one that was kind of interesting, and I don't know how much time we have. Are we
We
running
have
out?
time for you to tell us.
Oh, okay. Well, it came up in the immigration field. The Department of Homeland Security had a regulation under which they would issue no match, it was called no match letters, to employers when the social security number of an employee did not correspond with the records they had, the Social Security Office had on file. Somewhere along the way, they got the idea of including in the letter a warning to employers that they could be subject to civil and, in fact, criminal penalties if they didn't clear the matter up within a limited period of time and parenthetically fired the person. And so there was a request for preliminary injunction, or actually a TRO, because they were about to send these letters out. And so I heard quite a bit of testimony about why these discrepancies can occur for very innocent reasons, and how a number of people's jobs might well be jeopardized if an employer felt threatened by these letters. And the plaintiffs were a consortium of organized labor, Chamber of Commerce, and nobody really wanted these letters to go out. Anyway, I granted the temporary restraining order. I did it while what was called being the duty judge. In other words, the judge that is on call for that week when the judge who has a case that needs immediate attention is on vacation or at a conference or away. So it wasn't even my case. All right, so I issued this temporary restraining order. I got so much hate mail, and the court got so many vituperative emails. I was called every name under the sun for issuing this order. There was a talk radio fellow in Florida who encouraged his listeners to take appropriate action against the judge and put out my home address on his program. However, he got it slightly wrong. I just hope whoever really lived there was not attacked in any way. But I was just appalled. I had never seen anything like this. And then the judge to whom the case was assigned, who will remain nameless, he's a good friend of mine, on the bench, he came back and put in place injunctive relief. He got no letters. By now it had all blown over. I had taken all the heat on his behalf. But that was an experience, I've never had anything like that in my years on the bench. And the hatred, this emotional welling up, it's amazing.
I don't think members of the public, generally, not the people who are sending the hate mail, but the majority of people understand that this kind of thing occurs and what kind of goes into making these decisions.
Yeah, I don't think you have it in the back of your mind, really. Mm-hmm. And of course, we have lifetime we have a lifetime appointment. Mm-hmm. Unlike judges who stand for election, you don't have to be looking over your shoulder how people are going to perceive your decisions. And that's one of the benefits, frankly, of lifetime tenure, but there could be criticisms of that also, that judges get carried away with being judges and lose sight of a few other important principles as well. But in any event, I'm well in favor of lifetime appointments for both personal and professional reasons. And as I say, this never even occurred to me, and I don't think of it. I don't think of any kind of retaliation when I'm on the bench. But this was a surprise. Yeah, real surprise.
Well, as we just come to the end of our time for today, you talked about the phone call and the restaurant,
Oh, yes.
and when Jerry Brown was governor. How did it come about that you learned about your federal appointment?
You know, I'm trying to remember exactly when I got that call. You know, nothing exciting was happening at the time. I was just so happy to hear, because we had waited quite a while. A colleague of mine and I had gone through the hearing together, Judge Susan Ilston, and we'd both been waiting quite some time because independent of our own situations, there was a fight in Congress and the Senate about the Democrats and Republicans were feuding as they are wont to do and continue to do, and we were just held up in the crossfire. And I actually had to be renominated because things got held up for quite a while. But anyway, putting all that aside, it wasn't quite the same drama as the Superior Court. That was just unique. I wasn't doing anything in particular when I learned of my federal appointment, but I was exceedingly happy to receive the news. Yeah.
Were there particular groups among your colleagues who supported and the nomination and put your name forward?
I hope that people who were contacted spoke favorably of me. I think the support came considerably from the bar, sort of putting my name forward, on top of me putting my name forward, but from people who had appeared before me and who knew the senator and spoke about those experiences. At least that's my understanding. So I'm happy to know that. I like to think I did a good job. I hope I did on the Superior Court. I hope I'm still doing a good job on the federal bench. It's never boring. It's always an interesting job. I highly recommend it.
Well, it's wonderful to meet you and to have you tell us the stories you've told us today. So I want to thank you.
It's great to meet you too. Thank you very much.
Thank you, Judge.